Hello, hello. Welcome to our latest Reg Brief, where we will cover the important regulatory developments during the month of August. I'm Robert Brosh, and with me today are some familiar faces. We have Cheryl Grizzard and Alicia Briley. First, we are going to talk about the issues affecting the industry as a whole, and then really narrow in on depository institutions, our banks and credit unions, and then finish with our issues that affect everyone else. This was a month full of guidance, enforcement actions. We had crypto-related publications and also some cybersecurity news. But apart from all of that, I think the CFPB drama has been some of the most interesting content to follow from the month of August. So what's going on with that, Alicia?
Yeah, August was definitely a roller coaster month with the CFPB litigation injunctions and Section 1071. And we have a few updates that are hot on the heels from those that we talked about in the last month's update regarding the CFPB constitutionality case, the joint resolution to disapprove the 1071 rule, and plus that update about the Texas court providing some relief to Rio Bank, Texas Bankers Association members, and American Banker Association members by delaying the implementation start date for the association members, but not everyone got that golden ticket for that delayed start as requested. This whole situation has been a whirlwind of emotions, from upset to motivation and determination from a lot of institutions. And more institutions and associations are diving into the mix, trying to nab that delay for all players that are in that game. Take the ABA and the TBA, for instance. They scored an injunction win, and their members are in the delayed implementation bubble. But wait, there's more. They wrote a letter to the CFPB director asking for a broader delay to include all FDI insured banks. And they've got a point. A little consistency could make everyone's life easier. And that's what they were shooting for when they first put this injunction request into place. A Texas credit union and two credit union and trade associations have been granted leave to intervene in the lawsuit challenging the CFPB's rule that's pending in the Texas federal court. They also have an unopposed motion for leave to intervene that was filed by Rally Credit Union, the Credit Union National Association, the Cornerstone Credit Union League, and it followed a similar motion filed on August 4th by a Texas community bank and two community bank trade associations. Also, a group of Kentucky banks and a Kentucky Trade Association filed a new lawsuit last week in a Kentucky federal court. So they filed something completely separate instead of joining in with what's already happening in Texas. And don't forget about the National Attorney General versus the Credit Acceptance Corp case. You may remember the one about predatory auto lending practices. Well, it's a temporary pause related to the US Supreme Court case. A judge thought it best for everyone to hit the pause button and wait for that Supreme Court decision next June. And there's more coming our way. Oral arguments are set for October 3rd on the constitutionality case with the CFPB. And speaking of surprises, the Supreme Court denied a motion filed by the 27 Republican state attorney generals with no specific reason given. Go figure there that they don't provide a reason. And bottom line, brace yourself for more twists and turns. This isn't the last time we'll be talking about CFPB injunctions and legal battles. While we wait, keep charging forward with your 1071 action plan, especially if you're not part of the ABA and TBA club. Stay tuned from updates, especially from your associations, and let's see where this regulatory roller coaster takes us next. Moving on from these legal injunctions and cases with the CFPB, on another Section 1071 update, the CFPB updated its filing instructions guide for small business lending data collected in 2024. The CFPB issued updates to the filing instructions guide related to the data products for small business lending data. The updates consist of changes to validation IDs, updating them from name codes to alphanumeric codes, changes to the race and ethnicity enumeration for demographic, and this is to better align with the Home Mortgage Disclosure Act, and also minor wording clarifications to the pricing information data point. All right, that was a lot of CFPB and legal updates. I'm sure that there's more to come, and I know I could talk about this a whole lot more, but Robert, I'll pass it back over to you now.
Thanks, Alicia. Yeah, definitely going to be interesting. I'm sure a ton of you are going to be listening in to those oral arguments scheduled for October 3rd, especially if your institution is going to be subject to reporting under 1071. Now, I want to switch gears a little bit here and talk about some guidance that was released by the FHFA. This was guidance supplemental to an advisory published in 2021 on the framework for adversely classifying loans, other real estate owned, and other assets, and supplemental guidance for listing assets for special mention. Included in this guidance, the FHFA defines balance for financial assets, non-financial assets, and off-balance sheet credit exposures. They also talk about when to determine the fair value of collateral. They specify that contractual terms can be considered when evaluating a loan for classification. They also talk about how to classify loans for borrowers who have declared bankruptcy but remain current on payments. And there is a lot more in that supplemental guidance. I think total there are about 15 to 16 different topics. So if you are one who sells your mortgages or services for Freddie or Fannie, definitely go in, make sure that you are up to date on all of the supplemental interpretations and information that the FHFA has published in this piece of guidance. And now we're going to switch gears a little bit more. I think we have a RESPA enforcement action. Cheryl, take it away on that one.
Yes, Robert. Unfortunately, we still continue to hear about these sort of enforcement actions in the news. Well, this particular enforcement case involves a mortgage company, Freedom Mortgage, for RESPA violations. Now, in this case, the CFPB alleged that Freedom Mortgage Company was giving special incentives or kickbacks to real estate agents and brokers who sent people their way for mortgage loans. One of the real estate brokerage firms that Freedom was working with was a company called Realty Connect. Realty would send prospective home buyers to Freedom and in turn receive illegal rewards for their referrals. Now, some of the conduct that Freedom was alleged to be engaged in was paying referrals through agreements that were supposed to be about marketing services. However, Freedom was giving brokers money for sending them customers instead of providing real marketing work. They were also accused of giving brokers and agents access to premium subscription services free of charge, which gave them access to valuable information about property reports, comparable sales, and foreclosure data. The CFPB also found that Freedom required loan officers to be paired with real estate agents in order for them to have access to these subscription services. The CFPB said that Freedom hosted specific exclusive parties for certain real estate agents and brokers. They gave them free tickets to sporting events. The list goes on and on. In this case, the CFPB made it very clear that they are committed to stopping this sort of unfair and anti-competitive behavior, and that these types of unfair practices make it hard for people to make informed decisions about financial services, because RESPA is designed to make things fair for home buyers by encouraging healthy competitive practices in the mortgage industry. So as a result of their actions, Freedom was fined $1.75 million, and Realty Connect will have to pay $200,000, and they're not allowed to offer special rewards for referrals anymore. So some key takeaways for institutions engaging in mortgage lending are to make sure that you are familiar with provisions of RESPA, The CFPB has a list of FAQs that address questions surrounding RESPA requirements that are helpful. And of course, we have compliance and other helpful materials in our in-compliance software. So as always, we will continue to monitor and report on these types of violations to help you stay on the other side of these enforcement actions.
Thanks, Cheryl. Yeah, what's the saying? It's like if it walks like a duck, if it quacks like a duck, and if it looks like a duck, it's probably a duck, right?
Yeah.
It kind of applies here. If it looks like a kickback, it smells like a kickback, it probably is a kickback, and the CFPB is not going to be deceived about it. Very interesting there. Now I want to talk about some cybersecurity. We constantly hear about cyber attacks and ransomware for depository institutions, but we did have a new type of target for some cyber criminals last month, and that was multiple listing systems, these MLSs. So they are basically a valuable tool for appraisers to develop and report appraisals for loans sold to Freddie Mac. So lenders really need to understand that this attack that we did see in August means that appraisals may take longer. They may honestly not be completed at all until MLS access is restored, and that can result in a delay of closing for your borrowers. And so as the lender, it's your institution's job. You probably want to communicate this information with your borrowers, right? Transparency is going to be key. If you can avoid these complaints in the long run because of upfront communication, you're definitely going to save yourself some time and resources. So like I said, just an interesting and new novel type of cyber attack, or the specific target that these cyber criminals were focused on. So it'll be something that we watch as well in the future to see how we can continue to make sure that our cybersecurity principles and policies and procedures are up to date to protect our consumers as much as possible. And now, Cheryl, I think you have another enforcement action. It was a month of enforcement actions, lending, I believe, too. Is that right?
Yes, Robert, back to me to report on another enforcement action. Well, this case involves a DOJ enforcement action against American Bank of Oklahoma for engaging in redlining. Now, redlining is a hot topic amongst the regulators, and we've discussed redlining before in previous updates. It's an illegal practice involving lenders avoiding providing credit services to individuals living in certain communities of color because of their race, color, or national origin. Now, in this case, the affected area included the historically Black neighborhoods that were the site of the 1921 Tulsa Race Massacre. And for those who may be unfamiliar, this particular neighborhood was a thriving and successful area where many Black families lived, worked, and built businesses. The area was burnt down because of racial tensions and certain unfair treatment of Black people. And back then, the local government didn't adequately protect these residents. So after the neighborhood was destroyed, the residents had to rebuild from scratch. So the complaint from the Department of Justice in this case alleged that from 2017 to 2021, the bank failed to provide mortgage lending services to Black and Hispanic neighborhoods in Tulsa, that all of the bank's offices were located in majority white neighborhoods, that the bank designated a service area that excluded all majority Black and Hispanic census tracts in that area, and that the bank failed to appropriately monitor and address their fair lending risks. So as a part of the DOJ's combating a redlining initiative, they proposed a consent order with the bank, and the bank has agreed to invest over $1.15 million to increase credit opportunities in neighborhoods of color. It will also invest at least $950,000 in a fund for residents of Black and Hispanic neighborhoods. And as I mentioned before, regulators are paying close attention to redlining violations, and they're coming down pretty hard on institutions for making these violations. So some key takeaways to keep in mind here are just make sure that you are providing regular training to your lending staff especially. Like I said, it is a constant hot topic and a supervisory priority. Review your current lending practices. Make sure that your lending decisions are not being influenced by race or color, and that they comply with fair lending laws.
Thanks, Cheryl. Yeah, sad that we're basically talking about redlining and discrimination every month during these, no matter how much we talk about it, it seems to still pop up. So definitely take Cheryl's tips there and make sure that your institution is cutting down on this as much as possible. Lots of times our institutions are doing it unintentionally, but that ignorance isn't an exemption to the rules. So now we'll transition to some cryptocurrency. The Treasury and the IRS proposed a rule requiring brokers, and brokers are digital asset trading platforms, probably not a lot of your institutions, digital asset payment processors, which could be your institutions, and then certain digital asset hosted wallets, again, it could be some of your institutions, to file information returns and furnish statements on the disposition of digital assets affected for customers in certain sales or exchanges where digital assets are involved. So digital asset payment processors under the rule do include payment card issuers that make payments in a digital asset to a merchant acquiring bank. I know some institutions are looking to really innovate the way that you are looking at cryptocurrency. Some cards are being issued that allow you to receive rewards back, for example, in Bitcoin or other digital assets. So you may very well be subject to this rule. I will say within the proposal, example 16 is fantastic to determine whether or not the rule is applicable to you. And then along with this proposal, real estate reporting persons are also required to report the fair market value of digital assets that are part of the consideration received in a reportable transaction, in a real estate transaction. And so those same people are also required to file information returns and also furnish those statements as well. Generally, right, that is normally the person responsible for closing the transaction, your real estate agent, for example, or your settlement person. But if no such person exists, it actually means that the mortgage lender, your institution, if you are the lender, may be the person that needs to report and file. So again, if your institution is looking to begin offering these new and innovative digital asset products and services, you should certainly read up on how this rule might affect you and what all of the new requirements would be that your institution has to go through. And kind of continuing down that vein of the crypto sphere, we do have some supervisory guidance or a notice from the FRB for our FRB supervised banks. And Cheryl, I think you have the down low on that.
Yes, I have the tea. So the Fed announced that it has created a novel activities supervisory program that's designed to keep a close eye on novel or new and unique activities that banks are interested in getting involved in, including new technology and partnerships with third parties like fintechs. So the goal of the program is to make sure that these activities are being performed in a safe and sound manner. The Fed feels that new technology can improve banking and make banking more efficient, but they do warn that this can bring new risks that institutions must understand and properly manage. So the program will focus on things like partnerships with non-banks. This includes using technology to improve the efficiency of certain operations. It will also focus on crypto-related activities, which include holding cryptocurrencies for customers, lending with cryptocurrency, and even trading it. It will focus on using blockchain technology to keep track of transactions, like issuing digital tokens or securities, and working with crypto-related companies. The Fed will inform banks whose novel activities will be subject to examinations, and they'll do that in writing. And then for banks seeking to engage in these novel activities, the Fed advises that they will need to obtain a notification of supervisory non-objection before engaging in blockchain and similar technologies in order to facilitate payments. They stress that in order to receive a non-objection, the banks must demonstrate that they have established appropriate risk management practices for the proposed activities. So including things like having adequate systems in place to identify, measure, monitor, and control any risks that may be associated with the activities. So if your institution is interested in participating in these types of novel activities, now is the time to start getting the appropriate teams involved. Look at any planned activities that may fall under the category of novel activities. This could be partnerships with non-bank entities to offer technology services or any services involving crypto assets and blockchain technology. You definitely want to perform a risk assessment to assess potential risks associated with those novel activities. Make sure you have proper safeguards in place to ensure that you can conduct these activities safely and soundly. You will, of course, want to train your staff, make sure that they're on board. And then again, conduct monitoring, ongoing training to make sure that your activities are going to comply with the Fed's requirements under the program.
Great. And like I said, I do think August was the month of guidance. We also had a bulletin, Alicia, I think, released from the OCC. Is that correct?
That's correct. The OCC released guidance bulletin aimed at providing banks, particularly community banks, with clarity on the application of the legal lending limit, or triple L as a lot of us refer to it as, to provide more clarity for these banks, and underscores the loan purchase practices serving legitimate business needs driven by extensive network of loan broker channels and non-bank lenders, which has expanded loan availability. The guidance highlights purchase loans can be attributed to sellers under certain conditions of recourse, explicit or implied recourse scenarios, and that determine this attribution, with examples provided for both. In cases lacking recourse, purchase loans generally fall under the triple L regulation for named borrowers unless specific criteria are met. So if you are an OCC bank, make certain to check out that bulletin in more detail.
Thanks, Alicia. Now let's go to our credit unions. It feels like I'm constantly talking about the regulators and their cyber incident notification rules. Last month, I discussed the SEC's proposal, and this month, NCUA is back on the docket. It did release a letter to credit unions on the cyber incident notification requirements. So with the final rule effective September 1st, 2023, probably the day that this comes out, or maybe a few days before actually, it's probably best to go in and make sure that you are giving this letter a read to ensure that all of your T's are crossed and your I's are dotted. Make sure you have updated your response plan, review your contracts with third-party service providers so that they're providing you proper notifications. Make sure you're training your employees, have a monitoring and review system in place, and then also just make sure you have a plan for accurate and timely documentation of all of these incidents. I know you all probably know this rule by now. Just as a refresher, right? You have to notify the NCUA within 72 hours of your institution becoming aware of a cyber incident that severely disrupts your operations, maybe places consumer information in harm's way. So definitely, like I said, go ahead, make sure that your plan is in place and you are ready for that effective date that is here already. And finally, we will finish with another interesting one, honestly, involving texting. And Alicia, I think you have some information there.
Let's first start by transporting ourselves back to the fall of 2022, when a significant event unfolded. 16 major banks found themselves collectively fined $1.8 billion by both the SEC and the CFTC for these texting. And what prompted this hefty penalty? The use of private texting applications without proper communication records, which directly violated essential record-keeping regulations. In response, the SEC and the CFTC made a clear demand for enhanced policies. Moving forward to this month, a new chapter unfolds as the SEC takes action against 11 Wall Street firms. These firms have been charged with extensive and long-standing failures in upholding proper electronic communication preservation, which is a direct violation of federal securities law record-keeping provisions. These firms have admitted to their mistakes and agreed to pay a combined total of $289 million in penalties. The investigation that led to these charges unveiled a pattern of off-channel communication among these firms. And these include names like Wells Fargo, BNP Paribas Security Group, and these communications taking place on personal platforms such as iMessage, WhatsApp, and Signal. And it pertained to business discussions. Unfortunately, these crucial communications were not appropriately stored or maintained, which hindered the SEC's ability to effectively oversee and enforce compliance. These charges brought against the firms involved breaches of record-keeping regulations and a failure to exercise reasonable supervision. Beyond monetary penalties, the firms are now obligated to enhance their compliance policies and engage independent compliance consultants. Additionally, in a parallel development, the Commodity Futures Trading Group Commission, or CFTC, imposed penalties on affiliates of those institutions. These penalties amounting to $260 million were linked to that similar lapse in record keeping and supervision. The fines for these texting sweeps total $549 million collectively. And given the substantial fines and the regulatory spotlight on these matters, it's prudent to reflect on the state of your own institution. This serves as a reminder to assess your organization's practices and ensure that they align with regulatory requirements. In a world where even Wall Street's giants face significant consequences, taking proactive measures to secure your success and protection is really important. And the situation has prompted us to contemplate the repercussion of these texting practices, which have ultimately led to discontent among regulators and the delivery of a billion-dollar message.
Thanks, Alicia. Yeah, it's funny to think about, right? You're sending a text message that costs $549 million. It's wild to think about. But as always, thank you for joining Cheryl, Alicia, and myself this month discussing all of the important developments in the financial services industry during the month of August. I'm excited. We're starting to move into fall, definitely, in my opinion, the best season of the year. Please join us next month for all of the happenings that occur during September. And we also look forward to seeing a lot of you at Engage in October. But in the meantime, please be sure to check your Ncomply solution for other regulatory updates, guidance, news, and more. Thank you.